My name is Nicholas Zimmerman. Today's date is September 14th, 2018. Time now is about 9:38 a.m. Location is Wendy Correctional Facility in upstate New York. Title of this recording is Innocent Prisoner Seeks Legal Representation, Media Attention, and Public Support to Help Overturn His Wrongful Conviction. This recording is intended for reporters, lawyers, law students, advocates, paralegals, private investigators, and/or anyone else trained in the field of law. However, if anybody else decides to take interest in what I say here and would like to help me in any way, your support will be very much appreciated. I make this recording with the hopes and intentions of securing legal representation and media attention for my case. In this recording, I will explain the most pertinent and important parts of my conviction so that an attorney or a reporter will have the information that he or she needs to make an informed decision regarding accepting my case. The facts of my case are as follows. In 2001, I was convicted of criminal possession of a weapon in the second degree and one count of menacing based on the testimony of Nakia Stubbs, who alleged at trial that on September 19, 1998, at 3 a.m. in the morning in Rosedale, Queens, I attacked her by pulling her out of her car, dragging her several feet, and then firing a gun in the air before leaving the scene of the crime. Although Nakia was the only identifying witness at the trial, Assistant District Attorney Lee Bishop corroborated her story with the testimony of Carisha Brathwaite, Nakia's friend, who stated that Nakia was attacked but that she could not herself identify the assailants, with shell casings found at the scene of the crime and testimony from a resident that lived on a block that said she heard gunshots on the night Nakia Stubbs was attacked. Stubbs alleged that I attacked her because of a dispute we had over a rental car agreement that she made with my then girlfriend, Jatanya Bell Navis, who also happened to be an acquaintance of Nakia Stubbs. Since this case was based on the tainted and unreliable identification testimony of Nakia Stubbs, Lee Bishop used the acquaintance of Jatanya and Nakia and the car rental agreement that they had to make it seem like Nakia and I were good friends as well, even lying to the courts several times alleging that Nakia and I went to school together when such was not the case. She used this faulty information to convince the jury that this was not a case of mistaken identity because Nakia and I were known to each other. After the trial, we will find out that Nakia's entire identification testimony was fabricated and coerced. In 2003, I hired former New York City detective Kevin W. Hinkson to interview Nakia regarding the testimony she gave at my trial, and based on what she said, we immediately started to figure out how I was implicated in this case. For one, Nakia said that Lee Bishop told her that if she did not testify against me, she would be held in jail until she agreed to identify me in court. She also said the detectives handling the case showed her a single photo of me for the purposes of identifying the suspect in the case. This single photo showing violates both federal and state law, as suspects are supposed to be identified by a 6-picture photo array or a 6-person lineup to avoid the possibility of a suggestive identification. To make matters worse, she also said the detectives had to convince her that I committed the crime. Nakia signed a sworn affidavit before Hinkson, stating that she was never certain that I committed the crime and that she had only seen me on 2 occasions prior to the incident and was not familiar with me at all. She said she associated me with Jatanya Bell Navis. Because Nakia's affidavit still left some open questions about her identification of me, I contacted her directly in 2005. In a recorded conversation, Nakia Stubbs candidly explained to me that her testimony was, quote, coached very well by Lee Bishop. She said that Bishop hand-fed her whole testimony. Nakia alleged at trial that she knew that I was the one that attacked her because she recognized my voice as she was pulled out of the car, that her overhead lights in her car came on and she had a clear view of my face, and that she had seen the Jeep Cherokee that she had rented to Jatanya at the scene of the crime, and therefore she was certain that I was the one that attacked her. However, when I asked her about these statements during our conversation, she confirmed that all of this was a lie, and that this part of her testimony, as well as all of her testimony that implicates me in this crime, was forced upon her by Bishop. More importantly, Nakia Stubbs confirmed that Assistant District Attorney Lee Bishop allowed her to commit perjury on the stand when Nakia denied that Bishop had offered her a deal to testify against me, when in fact Bishop had told Stubbs if she helped to convict me, she would get her a reduction in her prison time on her pending federal charges. Besides the coerced identification testimony by Nakia Stubbs, there is yet another compelling issue in my case. I was denied my Fifth Amendment right to call alibi witnesses and present evidence at trial that would have proven that I performed at Jam Rock nightclub in Hempstead, Long Island at the same time Nakia was attacked. Even more, I was denied my right to call evidentiary witnesses that would have testified that they were present for the attack of Nakia Stubbs and that I was not the assailant and that I was not even at the scene of the crime. These witnesses' testimony and the evidence was denied by Judge Roger R. Rosengarten of the Queens Supreme Court simply because my trial attorney, Brendan O'Mara, forgot to add this evidence to the notice of alibi form at the start of the trial. State and federal case law holds that a defendant's alibi defense should not be denied because of the failure to list it on the notice of alibi. However, Rosengarten ignored these laws and denied it anyway, and every appellate court I have appealed to over the years has ignored these issues and the law surrounding them as well. There are many more issues in my case, including the fact that there was never a gun recovered. One of the elements of criminal possession of a weapon in the second degree is that the weapon must be tested to ensure that it is operable and capable of causing harm. A weapon was never found in this case, so no test was ever performed, yet I was still convicted of criminal possession of a weapon in the second degree. In the interest of brevity, I won't get into the rest of my issues here. However, I hope I have said enough to get the media's attention and the public's attention. Over the past 17 years, I have presented all of the evidence of my innocence to the state and federal appellate court systems, and every judge has come up with every unreasonable excuse one can think of to deny my appeals. However, a major change recently took place in the court system regarding cases of actual innocence that eliminated one of the main excuses that the judges have been using against me for years. In order for a convicted prisoner to overturn his case based on actual innocence, he must file in court a motion pursuant to Criminal Procedure Law 440.10, or what is commonly referred to as a 440 motion. One of the requirements of a 440 motion is that the evidence must be, quote, newly discovered and cannot have been known about at the time of the trial. When I presented Nakia Stubbs' recantation affidavit, my alibi witnesses affidavit, the evidentiary witnesses affidavit, and all other documents that relate to my innocence, Judge Rosengarten denied it under the excuse that none of it was, quote, newly discovered because my lawyer, Brendan O'Mara, knew or should have known about all of this evidence during the trial. When I countered that by arguing that my lawyer was then ineffective and that I should be given a new trial and not forced to stay in prison for a crime I clearly did not commit because of my lawyer's mistakes, he denied that part of the motion without even a response. However, as stated previously, a new law has been passed that eliminates all of these excuses that the courts have used against me for almost 20 years. The new law passed by the New York State Appellate Division, 2nd Department, can be found at People v. Hamilton, 979 NYS 2D 97. What this law basically does is eliminate all the excuses that judges have used for years to hide, keep quiet, sweep under the rug, and rubber stamp 440 motions dealing with cases of actual innocence. As it stands now, it doesn't matter if the evidence is newly discovered, if it was known about during a trial, how it was obtained, etc., etc. So long as the evidence presents a strong showing of actual innocence, the defendant's case should be overturned and he shall be set free without a retrial. This law was passed because of the alarming number of wrongful convictions and cases of actual innocence that have surfaced in the past 5 years. I briefly cite this new law in this recording. However, I have written a 10-page essay entitled The 440 Motion Crowdfunding Campaign, which details all similar actual innocent cases like mine and how the law was used to obtain the release of several prisoners. I pray that everyone listening to this recording will take some time to read the essay as well. As stated at the starting of this recording, I'm hoping the issues I present here is enough to get a lawyer's attention to accept my case or to at least contact me for more information if needed. Same goes for the media. I hope a reporter listening to this recording would be willing to publish a story regarding the facts of my case in order to bring awareness to my situation. Similarly, I hope I have intrigued the public enough to want to support my movement to obtain my release by purchasing my book, My Side of the Story, The Investigation Part 1, on Amazon.com and BarnesandNoble.com, to purchase my album, Puz Pacino Presents New York's Illest, on Spotify, iTunes, and Google, and to make a donation to my legal defense fund at GoFundMe.com/the MAEG movement. That's GoFundMe.com/the MAEG movement. Of any amount, large or small, as all profits go towards me hiring a legal team to represent my case. I have set up a web page that contains every document and product I have mentioned in this recording. You can locate the web page at www.bit.ly/FreeNicholasZimmerman. That's www.bit.ly/FreeNicholasZimmerman. Remember that all letters in this link must be typed in lowercase for the link to work. This page holds the Nakia Stubbs affidavit as well as all other affidavits by witnesses in my case, links to my book, to my CD, to my GoFundMe page, links to all my appeals, the 440 Motion crowdfunding essay, the audio recording between Nakia Stubbs and I, etc. I ask that you visit this page as it contains all the information you need regarding my case. Anyone wishing to contact me about my case can do so by emailing me at themaegmovement@gmail.com. Again, that's the word the, M as in Mary, A as in Apple, E as in everything, G as in good, movement@gmail.com. Or calling me at 518-400-0917. You can also visit my Facebook page at facebook.com/FreeNicholasZimmerman. I thank everyone for their time and attention to this matter, and I look forward to working with anyone that's willing to help and assist me with my release. Thank you for your time.